day and welcome to this week's edition of Strictly Legal on WESN Content Capital. I am your host, Rondell, attorney at law. Once again, I'm happy to be here. Once again, I'm happy to bring the law and you. And of course, this program is to educate, inform, and to entertain. And none other than WESN Content Capital, where you can stream us on all social media platforms, including WESN-CC, as well as traditional media. Not forgetting our podcast, Strictly Legal with Rondell A.Donawa. And today, I'm very privileged to have a guest via virtually who will be speaking about a landmark decision that was recently concluded in the High Court of Justice in Trinidad and Tobago concerning domestic violence and accountability, none other than Douglas Mendes, Senior Counsel. But before that, we have our new segment, which is Legal Lingo, where we would basically describe and explain different legal terms that may be unfamiliar or may be confusing to you. So let's hear it, Legal Lingo. Our legal word for today is precedent. A precedent is a ruling that a court has already established, and lower courts usually follow the decisions, or what we call the precedent of the higher courts. Precedents are used to settle similar legal matters by applying cases and legal issues that have already been decided by a court. And in its context, of course, this case that we are going to discuss would have established a precedent. And if it goes through without an appeal, let's say that this case has been fully decided. Yes, it has been fully decided, but let's say there's no appeal, there's no further decisions. Therefore, courts of a similar nature may apply these principles. Or let's say, for instance, the matter has been appealed and the appeal has upheld the decision of the lower courts, then the lower courts will have to take the decisions of the higher courts. So that is precedent. So let's take a break and we'll be right back with more. And we are back on Strictly Legal on WESN Content Capital. And as I said before, today we will be discussing a landmark decision in domestic violence accountability titled Justice for Samantha. And just a bit of background without going too much into detail, because of course we will have the guests to discuss about it. Samantha Isaacs, she was a domestic violence victim who was shot in both legs and behind her head by an abusive, jealous, and possessive ex-husband or ex-boyfriend 6 years ago. And on May the 16th, Justice Mohammed held that her rights and that of her mother, because her mother basically filed an action and her son to the protection of the law and respect for private and family life. And what the court would have indicated is that their rights were infringed by the inaction of the police and the judiciary. And she would have requested basically certain declarations, as well as the court awarded compensation. And we will discuss in terms of how this matter came to fruition, what were the legal principles, some of the facts, and all those things that build this matter of accountability. And of course, the reason why this is a novel case and why this has been a landmark ruling. And as I said, I have no other than Mr. Douglas Mendes, Senior Counsel, and I'm so happy and so privileged to have him with us. Good day, sir.
Hi, Rondell. How are you?
I am good. And how are you doing?
I'm fine. Thank you very much.
Nice. Good to see you relaxed out of the courtroom setting and everything like that.
I'm glad to be on your program. I like the professional finish.
Thank you very much. We strive our best on WESN. All right, so let's go right into it. So basically, this matter, I mean, it's 100 plus pages of text in what we call a judgment. This matter is an application that was for redress in accordance with certain sections of the Constitution by the mother and, of course, the next friend and we will discuss what the next friend is of the the victim's son against the Attorney General of the Republic of Trinidad and Tobago for certain compensation or certain declarations. Can you just basically summarize what this matter basically was about?
Okay, essentially it was about the failure of the state through the police service and then through a magistrate who was tasked with hearing an application for protection order under the Domestic Violence Act. The failure on their part to essentially do what was necessary to protect Samantha's life from her partner in circumstances where she had a relationship with him starting in around 2012, and it ended with him killing her in December of 2017. And during that period of time, she was subject to abuse, physical and emotional abuse by him. There were occasions on which she reported his behavior to the police. And eventually, in the months preceding her death in December 2017, she approached the court for protection. But essentially, the responses both from the police and from the court was much less than what would be expected in modern-day Trinidad and Tobago, with a up-to-date Domestic Violence Act, which is designed to provide this sort of protection. But essentially, the state failed her, and she died at the hands of an abusive and violent partner. So the action was brought by Samantha's mother, Tot Lamkin, on behalf of Samantha's estate, but also on behalf of Samantha's son, who, as a consequence, and this was the case that was being made, as a consequence of the state's failure, essentially lost his mother, lost the family life to which he is entitled as a matter of constitutional right under the Constitution. So it was a proceedings essentially seeking to hold the state to account for their failure to take appropriate action in order to protect her rights. And that's in summary what it is about.
Right, and of course, I mean, there are frequent domestic violence matters that come before the court, ends up in death, and it seems to be a growing trend in terms of what we consider the inaction of whether it's the judiciary or whether it's the police. Now tell us, what makes this case so novel and what makes this case different from any other type of matters, I mean, that may have resulted in domestic violence and death, ultimate death?
Well, I'm sure that it is no different from a number of cases in which domestic violence resulted in the death of the victim. And it is probably, or very probably, no different from many of those other cases where the death was preceded by reports to the police and the police failing to take the necessary action to bring the perpetrator to justice before the eventual murder take place. So I'm fairly certain is not much different to many of those cases. Of course, there are many other cases that it would be different from, either because reports may not have been made to the police, or applications for protection orders may not have been made, or there may be many cases of domestic violence which ultimately didn't result in death.
Yeah.
So I might say on the facts there are some unique features, but on the other hand, this is not something new. As a matter of fact, the judge, in his judgment, referred to the fact that the newspapers, as it turns out, just around the time that he was delivering his judgment, was reporting on other deaths that had occurred in a domestic setting.
Yes.
Even after reports had been made to the police, even after neighbors had been aware of what had been taking place, and there had been attempts to get the police involved, but they fell short. So that it's, in many respects, is not unique. In many other respects, of course, it is. What makes this case different from the, I suppose, many other reports of criminal activity that made to the police asking for police action is the ongoing threat to the safety of Samantha, and the police being made aware of the ongoing threat in a context where by now we should all know that there is a very good risk that this will end in fatal violence, as it happened in this case. So the
Yes.
context is the police being made aware of this violent young man. As a matter of fact, when one of the reports was made to the police were aware, and in fact, they brought to Ms. Lampkin's attention the fact that the perpetrator's grandmother had taken out a protection order. So the police were very well aware of his violent tendencies. So that is the backdrop to this case.
Yeah.
Going to the police, making them aware that somebody's life is potentially in danger, but the police not doing what was necessary in order to protect her life.
And we see here that there have been four, well, at least based on the ruling, there has been four reports that has been reported in terms of spanning from May 2013 directly down to December 2017, and
Yes.
and then basically what the police did was just visited, maybe warned, and then left.
Yes, the first report that was made, you might say, was, I'm not meaning to diminish it in any event, but
Indeed.
it was the least worrying because it was a report of damage to property. But the point is that is, as the judge pointed out himself, although that may not by itself have given the police an indication of a potential threat to life. Nevertheless, it is something that they should flag. They should know, in other words, that this may be a manifestation of things to come. So they should be on the watch.
Yeah.
This is an event that should be recorded so that it should be on file. So that if something happens in the future, when you check the file, then you see, oh, there was a previous occasion. The second occasion was one in which the police actually visited the premises when the acts of violence were ongoing, and they witnessed it themselves. They witnessed his fit of anger. They felt it necessary to restrain him physically, even to point a gun to his head. So dangerous did they themselves think that he was, and they then issued a warning. But once again, nothing happened. So certainly at that stage, the police couldn't say, well, I'm not aware that this fella is out there and he's dangerous and he has been threatening people's lives. He had a knife. I think on that occasion he had a gun. Maybe on the second occasion. Forgive me if I don't remember all of the details. The third occasion was in 2017, around mid-2017, where similar activity took place, threats with knives, threats with guns, violence. And then they called up the police that night, but the police couldn't come because they didn't have a vehicle. And then a report was made to the police the next day, and the police records themselves show the details of what was going on, including that there was a threat to life. And the police did nothing. As a matter of fact, the evidence that the police put before the court indicate the highest level of negligence, in that one police officer who said that the report was made to me said, well, I passed it on to another police officer, and the other police officer said, well, I wasn't there, I was not on duty, or I passed it on to somebody else. In other words, each police officer was passing the buck to someone else. The net result was that nothing was done. So you had a serious report of threat to life sitting there in the police station, but no one doing anything because, well, I suppose it slipped through the crack, dropped the ball, and nobody was sufficiently moved to ensure that something was done about it. So that was mid-2017. And it was just after that she made the she made the application to the magistrate for a protection order. We can come back to that if you like. But then the
Sure.
fourth incident, with the fourth report to the police, was the day before she was killed. And there was an altercation between the two of them. The police were called out and they were brought to the police station, this time in St. Clair, in which the police had reports of a fight taking place. It seems that Samantha may have given as good as she got on that occasion, at least according to Kareem. But the point is that the police had a report again of violence, but they were satisfied just to issue a warning and leave it at that. Of course, if they had checked their records, because by that time the previous reports were on the Versadex system, they ought to have realized, well, this might escalate. This is something that we have to watch, but they just let them go. And of course, the very next morning, Kareem murdered Samantha. So that is it. That was the context in which this case was being determined by the court.
Yes, for various occasions spanning a few years, and
Yes.
of course the inaction resulting in her death, basically the following day after that last report. And,
Yes.
and basically the response of the judiciary in that, based on documentary evidence that was obtained, Samantha filed 3 applications before the family court.
Yes,
for a protection order.
She initially filed one, it seems, in June, and it was withdrawn, or it wasn't heard for some reason, and then she filed again in August. And by that time, it was sort of galloping along, because the incidents that she reported in the application did not record everything that she was experiencing, because when she went before the magistrate, she was telling the magistrate that it is going on, other things are happening. He's threatening her, he's pulling her hair, he's destroying her documents, because she had some evidence of him posting some pictures of her online and so on, and she had brought that with her to the court, and he tore them up, and she was telling the magistrate all of these things as they went along. But the magistrate took the view, and this is the judge's analysis, or the magistrate seemed to be distracted by her belief that Samantha really was, or made the application for a protection order in order to fast track an application for maintenance for the child that she had brought as well. So the magistrate seemed to be distracted by her suspicions that this was not a genuine application for protection order. Even though Kareem had taken the position that he was quite happy to have an interim protection order made. He was prepared to give an undertaking. Yeah. And again, the magistrate just simply ignored that and adjourned the matter until the last occasion, Samantha didn't turn up. And then she took Kareem's word on that occasion that Samantha had said that she was no longer interested in the proceedings, and then she dismissed the complaint. So that was in around late October of 2017. So during the month or two that then ensued, there was no protection order in place. And well, events, as I've already described, then unfolded.
Yes, this is so unfortunate and so triggering at the same time. Now, in the application for redress, you basically, in your title, your intertool, the redress was made under Section 14 of the Constitution. Can you explain to our viewers and listeners why this was made pursuant to the Constitution?
Okay, so let me preface this by saying that although I am here explaining all of this and all of the legal principles and the legal approaches and strategies and so on, that there were a number of other people who were responsible for bringing these proceedings before the court. First of all, Roberta Clark, who was then the president of the Coalition Against Domestic Violence, was the one who had the vision to see that this was the type of case that had to be brought before the court in order to test the jurisprudence and to ensure that the judiciary stepped in at this stage in order to set certain guidelines.
Yes, and she
And
was our previous guest.
I also want to acknowledge as well the extraordinarily gifted work that was done by Mr. Clay Hackett, who was a junior in the proceedings, and a lot of the case law that was brought before the court was as a result of his research. You might say that I was just the window dressing. I presented the case. But what the case was about is a claim that under the Constitution, via the right to life, the right to the protection of the law, and the right to family life, that obligations are imposed upon the police, positive obligations are imposed upon the police and indeed the judiciary to take steps to protect life, to take steps to bring persons who have violated the law to justice. So that's what the case was about, and it was asking the court to establish positive obligations. Now, of course, we usually think of the Constitution as prohibiting the state from doing things rather than requiring the state to positively do things. In other words, the usual case is you say the state has violated my right because they have done something to me.
Yeah.
What this case was saying that rights have been violated because the state has failed to do certain things. It's the omissions of the state that were being focused on in this case. First of all, the right to life. Had to argue that the right to life under the Constitution put a positive obligation on the states to take steps to protect someone's life from being taken by a third party who is a private individual and is not a state actor. And likewise, the argument was that the right to the protection of the law also put positive obligations on the states to take action in order to protect persons from criminal activity. Of course, it is much easier to see that a right described as that, the protection of the law, would impose positive obligations, because how are you going to be protected by the law unless positive action is taken to put things in place so that you could receive that protection? And likewise, the right to family life. The case was about establishing positive obligations on the state to preserve your family life, and in this instance to preserve the life of the mother of this family, the daughter of this family, because of course Tot Lampkin, the mother, was also the beneficiary of a ruling that her right to family life was also violated in the circumstances of the case. So those are the rights that we were seeking to have vindicated. Why? Why come under the Constitution? Because this is the supreme law of the land. It is in the Constitution where our values as a democratic nation are supposed to be set out and are to guide all other laws and are to guide the activities of all state actors, police and judiciary and everyone else. So that is the place where we would hope and wish to find principles which put obligations on the state to protect persons from domestic violence, which is well known, and which of course cry out for action on the part of the state to provide that sort of protection.
And did you use any sort of, whereas yes, we're dealing with all the rights, the protection of the law, that was your arguments, right to respect of family life, and also right to life. What international human rights principles did you espouse in your arguments, if any?
Well, as you would know, and as the audience would know, there is a basic principle that in construing the rights under the Constitution, which are, of course, are expressed in very broad language, it is permissible to have regard to Trinidad and Tobago's international obligations in fleshing out exactly what these very broad words used in the Constitution mean. In other words, you assume that the rights that are declared in the Constitution would be consistent with our international obligations. So in that regard, there are a number of international conventions that Trinidad and Tobago has entered into, two in particular, the Convention Against Discrimination Against Women, the CEDAW Convention, and also the Inter-American Convention Against Domestic Violence, that is referred to as the Belém de, forgive me if the Spanish escapes me, but they're both instruments that Trinidad and Tobago has entered into on the international plane.
It's the Belém do Pará. Belém do Pará.
That is correct,
Yes.
yeah, Belém do Pará. Thank you very much. In which Trinidad and Tobago is essentially promised to take positive action to protect women against domestic violence, protect vulnerable persons in a family against the domestic violence of others. That is what, those are the international obligations that we have undertaken, and then they have had rulings under these conventions, particularly in relation to domestic violence, fleshing out the obligations of the state, in particular, establishing the obligations of police when reports of domestic violence have been made to them. Essentially, they must investigate. They must exercise due diligence in carrying out their duties to ensure that the requisite level of protection is offered. Of course, there were also a number of cases from the European Court of Human Rights that we relied on under the European Convention on Human Rights, which of course is incorporated into the British system through the Human Rights Act. So there are a number of cases as well dealing with the police obligations under the convention where there are reports of domestic violence. So we relied on those precedents on the international plane, and the judge accepted that it was appropriate for him to rely on those precedents, and in interpreting the obligations under the Constitution.
Now, if I want go ahead. Sorry.
Yeah, sorry, go ahead, Ronald.
No, I know there was a defense counsel, your colleague-in-law, who was also a senior counsel, who would have made a differing argument as to debunking your interpretation of the Constitution. I just want you to, for the purpose of just generalizing or rather having the opposing view, can you just explain what was their opposition, or how did they argue against your case?
Well, there were, you might say, the more technical arguments as to exactly what the language in the Constitution meant, but the broader opposition to imposing positive obligations on the state under the Constitution was on the basis of policy. The argument, the usual floodgates argument, that if you were to impose positive obligations under the state, then anybody who suffered as a consequence of the failure of the police to prosecute someone would be able to bring proceedings under the Constitution and claim damages for that. That the argument was that would impose an impossible obligation on the police, that out of fear of being sued, the police might prosecute in circumstances where they otherwise might not prosecute. And accordingly, it was the argument was that this was a step that the judiciary ought not to take to impose obligations that might hinder rather than promote the detection of crime. That essentially was the argument that was put forward. The judge was not persuaded, obviously, because the test that had been, or the tests, plural, that had been established by the decisions on the international plane that we relied on, including decisions from the UK Supreme Court, established the threshold test at a fairly high level. In other words, it is not any report that is made to the police and the police don't act, that might result in a breach of the Constitution. In this particular instance, the, the requirements are that the police, first of all, must be made aware of the threat to life, and it must be in circumstances where that threat is an imminent threat, in other words, requiring action.
Yes.
So the threshold test is high, but most importantly, is the ruling in this case, following the international precedent, that the Constitution requires, as part of the obligation of due diligence, it requires the police to do a risk assessment when an application, when a report is made to the police station. You do a risk assessment in order to determine whether this person's life is in fact in danger.
Yes.
And depending upon the result of that risk assessment, then you might take action or not, as the case may be. Of course, no risk assessment was done at all at any point in time during the course of the 4 years before Samantha died. And of course, it appears that the magistrate as well made no risk assessment at all, because she, as I pointed out, was befuddled by her belief that the application was really being made to fast track the maintenance application.
Yes. So really and truly, the court took a practical approach in terms of not recognizing or not interpreting the Constitution in silo, but broadly extending to the positive obligations that are required for state entities to protect citizens.
Yes, I mean the point is that the judge was very much aware of the fact that the police service is burdened by a number of reports of criminal activity. And the judge is also very well aware, the judiciary is very well aware, that the police have to pick and choose which reports of criminal activity they are going to expend their resources on. We have to accept that despite the fact that we are relatively speaking rich country, at least richer than many of our neighbors. Yeah. We are not like the very wealthy countries. We don't have unlimited resources, and therefore the police service maybe or is understaffed and under-equipped to deal with the great upsurge in criminal activity in Trinidad and Tobago. So we have to accept, from a practical point of view, that they cannot investigate every single report of an offense that is made to them.
Yeah.
So that it is not on every occasion, therefore, that someone reports criminal activity to them and they fail to take action, that would give rise to a claim under the Constitution. But domestic violence is different, because when a report of domestic violence is made to the police, they know, or they ought to know now, from experience and from the research that has been done, that was referred to by the judge in his judgment, that this might be the tip of the iceberg, that this report is made, but victims of domestic violence don't report every act of violence to the police. Mm-hmm. So when one report is made, they have to realize it's because the person built up sufficient courage to make a report to the police. And it probably means that there have been other acts of violence before they reach this stage. And again, the experience should tell them that once this report is made, if nothing is done about it, then the violence is going to be repeated. Yeah. And so this is a special type of case, and this is what the judge was pointing out. Reports of domestic violence have to be treated in a different way from other reports of criminal activity, although all reports are serious. But the point is that when a report of criminal activity of domestic criminal activity is made, the police have to be put on the alert immediately that the person who is making the report is in danger. And therefore, in other words, they have to presume that they are in danger, and therefore start by doing your risk assessment report in order to determine whether they need to intervene and what intervention needs to be done.
Yeah, and what is interesting is that even in part of the evidence, and I would read verbatim, whereby the court adopted into domestic law the Belem Powder Convention, and basically the court noted the short title or the preamble to the Amendment Act or to the Domestic Violence, I believe it's the Amendment Act, and the court stated, basically read from the preamble, whereas incidents of domestic violence continue to occur with alarming frequency and deadly consequences, and whereas it has become necessary to reflect the community's repugnance to domestic violence in whatever form it may take, and further influence the community's attitude and support social change in respect of this social ill, and whereas the government is of the view that one way to achieve this goal is to strengthen legislation to ensure prompt and equitable legal remedy for victims of domestic abuse. And then it goes to state, by virtue of the Act, certain sections of the Act empowers the court to grant protection order. And then it goes on to state that there's a duty of the police officers. One, a police officer shall respond to every complaint or report alleging domestic violence, whether or not the person making the complaint or the report is the victim, and it goes on to state further subsections of the Act in terms of the duty. So the intention of Parliament was to strengthen legislation, and because of the prevailing instances of constant domestic violence abuse. So it seems to be the issue is really execution, or rather following through of the legislation by the state institutions.
Well, so I think you could say that in this instance, in Trinidad and Tobago, the legislative arm of the state did their part in that they passed legislation, they created mechanisms, they created a structure whereby protection against domestic violence can be obtained. And a lot of resources was put into creating those structures. The police service itself responded by creating special units to deal with domestic violence, so that they responded in that way. Of course, there are still ways in which the Domestic Violence Act can be improved, but that would be for another conversation with persons who know better than I do about that.
Right.
But as you pointed out, all of these wonderful mechanisms that are put in place under the Domestic Violence Act now have to be executed. They have to be implemented. And that is where there was a failure on the part of the police and the magistracy in this case. They didn't do their job, essentially. That's basically what it amounts to. They didn't do their job. And I should point out that the Police Complaints Authority became involved in this matter, and they investigated the police response to Samantha's reports and so on. And they made recommendations to the Commissioner of Police that disciplinary action be taken against named police officers, and nothing was done.
And nothing was done. I want to take I want to stick a pin here because I know we have more to discuss, but we want to take a break firstly, and we'll be right back. And we are back. You are watching Strictly Legal on WESN Contents Capital, and we are speaking with Douglas Mendes, Senior Counsel, on the landmark decision with respect to domestic violence. And before the break, we were discussing the courts. Basically, the courts. I'm not sure if it is a directive for the issuance of disciplinary action against of named officers. But Senior Counsel, can you just expound on that particular point?
No, the court didn't make any orders as far as that is concerned. The Police Complaints Authority had made a recommendation to the Commissioner of Police that disciplinary action be taken. The court referred to that in its judgment as part of the background. But I'm just mentioning it by the way that seems to be an indication that the police have not been taking it as seriously as one would prefer. Even where the Police Complaints Authority itself recommends disciplinary action, no action was taken.
And do you think that by the inaction I mean, I know that, well, maybe this could be cautious, but do you think by the inaction of the police service to take disciplinary action against their officers, does this in your view means that they are not taking the issue of domestic violence seriously?
Well, it makes you worried that is in fact so, but whether the particular commissioner of police who was responsible for deciding not to take action has that view or not, the point is that the inactivity sends a message to the police officers involved and to other police officers that we are not really going to take these findings of failures on your part. We're not going to take them seriously. We're not going to discipline you for it. So it's sending a message, intentionally or not, to the entire police service that the hierarchy of the police service don't really consider these things to be worthy of disciplinary action. So that is worrying.
And I would also think, I will also think that if disciplinary action is to be taken against officers and the police enforce those disciplinary actions, it may give a greater sense of responsibility or duty for the officers to actually do their job.
Precisely. Because what the Police Complaints Authority found was that it was your failure to do the necessary investigation and, well, first of all, investigation, and then ultimately charging for criminal activity. That constitutes an act of misconduct. That was the finding of the Police Complaints Authority, and it is saying to them, take disciplinary action. But by the failure of the Commissioner of Police to do anything about it, he's saying to police officers that it is not an act of misconduct to fail to do your duty in these circumstances. Yeah. So the message is that there's not going to be any repercussions against us when we fail to take action. The repercussion would be, as this case now demonstrates, a claim against the state for compensation for the violation of constitutional rights. So when the court ultimately puts a dollar figure to the violation of rights in this instance, then that money is going to be paid not by the police officers themselves out of their pockets, but by taxpayer. So once again, although you're successful in this case, none of the police officers who were responsible for the dereliction of duty that this case demonstrates are going to suffer personally. So there's no message being sent to them directly that they have to do their job better.
Yep, and tell us, I mean, there was a suggestion of alternative remedies in this action. Can you just explain what alternative remedies were there or they were noted to be rather than following this particular course of action?
Okay, so what was being suggested by the state was that instead of coming under the Constitution, they're saying that Samantha ought to have, first of all, appealed the decision of the magistrate for failing to issue the interim protection order, or to sue the police in negligence for their failure to take action.
Why must they do that? I mean, you are in an incensed environment. That is cost. That is a lot of emotional trauma. I mean.
Well, exactly. I mean, the point is that the Domestic Violence Act has been designed in such a way that victims of domestic violence can go to the court and make their own complaints without the need to hire a lawyer to do so. Because if you're going to hire a lawyer, you have to pay for that. And from a broad perspective, why should you have to be paying a lawyer in order to protect your life? That's the state's responsibility. So the legislature did their part by making it possible for persons to make applications to the court on your own without involving a lawyer. But again, the presumption is that when you go before the magistrate is going to protect you. The magistrate is going to take steps, appreciating that you don't have legal advice and so on. And at the very least, issue an interim protection order. If it turns out that there are some legal issues that need to be resolved, as opposed to just making findings of fact, well, then lawyers might become involved. But the whole point is that the whole design of the legislation is that you don't have to incur the expense of hiring a lawyer. So the state was arguing, well, you should have appealed. Well, it's very difficult for a layperson to appeal.
Yes.
Because you have to know the procedure, you have to know the time limits, you have to know what documents to file, and the registry of the Court of Appeal is not set up to process those appeals easily on the part of laypersons. So again, the suggestion is that you need to go through the legal expense of appealing to the Court of Appeal in order to get redress in that way. And likewise saying, well, you ought to bring an action in negligence. But the point is that all of this was after the fact. All of this was after she had already been killed.
Yeah.
So we are looking in hindsight and saying, well, there were a train of events in place, and it led ultimately to her life being taken. And the question that the court was answering was, does the state bear any responsibility for this? Should the state have done something in the circumstances in order that may have changed the course of events? And that's the question that was being asked. I should say that the argument that there were alternative remedies was not an argument that was really pressed by the state attorneys in this case. It was mentioned, but they didn't rely on it strongly. But of course, the judge nevertheless had to answer it because it was an argument that was put on paper.
Yes, and in conclusion, the court opined that the exceptional facts of this case warrant a novel interpretation of the right to life, the right to protection of the law, and the right to respect for family and private life. And in essence, the court ordered certain declarations. Now, what does these declarations mean for Samantha's estate, or well, her mom, her son, who is basically growing up without a mother and a father?
Yeah. Well, the orders that the court has made so far are just declarations that rights have been infringed. The right to life, the right to protection of the law, the right to a family life, protection of family life. So all the court has determined at this stage is liability. There's another stage which must follow, in which the court will now assess damages for the violation of those rights. So there's going to be monetary compensation that will be awarded. We haven't gotten to that stage yet, but we'll have to put the necessary evidence and so on to substantiate the claim for compensation. So it means the first part of the case is over, in that the vindication of the constitutional rights has been declared, and now an assessment of damages will have to be done.
Now, seeing that this is a novel case, how would you approach, or how do you think the court is likely to approach the assessment of damages, or what to award for these rights being infringed? Noting that, I mean, any amount of money can bring back life, but it can be definitely a head start for the little one, basically the next of kin, who is left parentless for his future endeavors.
Well, it is. This is novel, of course. How do you assess damages for the police failure in these circumstances? Of course, there will be guidance in similar situations where persons' lives are taken as a result of the actions of a defendant, so that there will be some sort, as far as the estate is concerned, there will be some sort of assessment of the financial loss to the estate, which would be represented by the income that she would have lost as a consequence of her life being taken. As far as his son is concerned, there's a financial loss to him because he would have been taken care of by his mother once she was alive. So some sort of estimation of what that financial loss is would have to be undertaken by the court, and likewise, or to a lesser extent for Tot Lampkin herself. But some estimation is going to have to be made to the court of the loss that is suffered as a consequence of being deprived of the love and care of a relative, your mother and your daughter. So that the court is going to have to make some sort of assessment as far as that is concerned. And then there's another category of damage that the court will have to address, and that is a category called vindicatory damage, which is an award that the court makes over and above any award of compensation that that they had awarded, on the basis that the court feels it necessary to mark or fix that the other orders that it has made, the declarations of breaches and any compensation that it makes, is not sufficient to vindicate the right that has been violated. So that will be another area in which the court might award a monetary sum.
And then considering she was only 26 years old, I mean, that's your whole life gone. So I can imagine the award, whether or not the argument on your side will be a substantial award, considering the age of the parties, what they earn at the time, the fact that the son may have to go through school, tertiary education, all these varying factors. And I mean, it is indeed unfortunate, and even from that particular incident, we've still seen many other similar incidents up to today that has constantly being, that is a constant feat.
Yes, and when it is so easy just simply to investigate reports and do your job.
Yeah,
all of this could be avoided.
Could be avoided. So tell us, just as we are closing up, how do you see seeing that this is precedent in terms of future cases? How do you see potential matters being litigated from this decision, whether or not there may be an improvement in reports or rather action of the state, etc.?
Well, hopefully whether the state decides to appeal on points of law that they may not be satisfied with or not, I expect that the Attorney General will take the ruling seriously, because the message essentially is that the police are not doing what they're supposed to do. And maybe the Chief Justice as well might take the judgment seriously and put into place protocols as far as magistrates are concerned as to how they are to deal with these applications. As a matter of fact, the judge had cited a judgment of the President of the Caribbean Court of Justice, Justice Saunders, in which he was giving advice to magistrates as to how they should approach applications for domestic violence when it comes before them. So whether there's an appeal and whatever the outcome of the case going forward, I expect that the powers that be will respond to the sentiments expressed by the judge in this case. And I should point out that the judgment of Justice Mohammed was cited by a minister, I think it was in St. Lucia, who I think this was done in Parliament, citing the judgment and saying that this was the platform basically for action to be taken in St. Lucia or St. Vincent, I don't recall which at the moment. Yeah. In order to amend their laws in order to provide for greater protection for victims of domestic violence. So the expectation is that this is going to have an effect. It is precedent, but it's a precedent at the High Court level only. Yes. So it means that other High Court judges will have to treat with it with respect, although they are not bound by it. Yes. But it is precedent in that sense. But of course, it is a very well-reasoned judgment, a very well-written judgment. And it is supported by a number of other authorities, so that I would hardly think that it would be departed from, at least for the time being. But I suppose the ball ultimately will be in the Court of Appeals court if it goes there.
And it is a good legal reference point, both academically and as well for practitioners. And I must say congratulations to you. I mean, it is unfortunate. May Samantha Lamkin continue to rest in peace, and may her son and her family find that grace to continue life in her absence, and and the strength that the mother pulled through to the end of this matter. And I'm hoping that this is the end of this matter. But at least, and congratulations to Clay Hackett, yourself, and Roberto, who was in studio with us recently. Thank you, Senior Counsel, and any parting words? I know we are out of time. Studio is telling me wrap up.
No, I think that you should also send out kudos to Todd Lampkin as well, because she, it was an emotional experience for her. She was in my office when the judgment was being handed down, and of course the tears were flowing for a number of different reasons, of course. I'm sure part of it was happiness that the judiciary was recognizing and paying tribute to the life of her daughter.
Thank you very much, Douglas Mendes, Senior Counsel. We will certainly see you again, hopefully, and all the best.
Same to you, Rondell.
Thank you.
Thank you very much for inviting me.
Certainly. It's a wrap, guys. Thank you for watching Strictly Legal on WESN Content Capital. Of course, I leave you with this quote: either you run the day or the day runs you. Have a great day. God bless.